Good morning. This is Victoria Beale with the LTAP Center, and I'd like to welcome you to Acquisition 104 Instruments. I have with me this morning your instructors for the day. We have Greg Severance, who's an Associate Assistant Attorney General from the Ohio Attorney General's Office, and also Wayne Pace, who's the Acquisition Manager in the ODOT Office of Real Estate. And would like for everyone to, if they wouldn't mind, do me a favor and find your question box and drop a hi or hello in there. So that way I know that you have found that area, because that's how we're going to be accepting questions throughout the webinar. And your presenters will be stopping periodically to ask me for those questions. So feel free to put them in anytime while we have the presentation going. Also, I did email out the handouts about 20 minutes to half an hour ago, but if you didn't get that email for some reason, they are also available in the handout section of the GoToWebinar panel. So you can also click in there to download those. The only other thing I wanted to mention is we are trying to record the webinar series, and if that's successful, we'll send the links to the recordings out afterwards. So I believe that is all I have. Lots of folks are saying hi or hello. I appreciate that. So I believe that's it. Wayne, are you ready?
I am.
Thanks.
I will take my face off now. I just figured I'd let everybody know that I'm not doing this from my bed. And I did put a tie on. So with that, Wayne, you want to take off with this?
I take off. Well, good morning, everyone. My name is Wayne Pace, and as Victoria said, I'm the Acquisition Manager for the Ohio Department of Transportation, the Office of Real Estate, Division of Engineering. And we're just going to go through our Acquisition 104 instrument course. We tried to pare this course down significantly from our one-day course that we teach, but in interest to keeping everybody's interest up high. So we're going to go through the screen every now and then. Greg Severance, which is the Attorney General, will chime in to add some additional comments because this course is written on the basis for the Attorney Generals with the Department of Transportation. This is an overview of Acquisition 104. Any questions will be handled through the moderator, which is Victoria Beale. We're going to have knowledge checks just to keep everybody alert and focused with regards to this particular webinar. Student materials we're going to have will be the acquisition handbook, which is the PowerPoint. We'll have also the case studies. We're doing something a little different with our case studies this time around. We have decided to go ahead and allow you guys just to have the case studies. We're not going to go through them, but if you have those case studies, you can download them and use them at your own free will. And if you have any questions at the end of the presentation, you'll be able to email us with questions that you may have with the case studies. These are the attachments that we have with regards to the attachments that should be in the during this webinar. We have the components of the instruments with warranty deed, limited access, limited warranty deed. That'll be handled through Greg Severance. And then we're going to talk about the duties and powers of the director. And everything we're going to be talking about is with regards to Ohio law. So we're also going to be talking about a little bit of the interest in the dower of memorandum. We have a quick reference guide for you. We also have a agency and authority attachment there for you that Greg will be talking about later on during our presentation. We're going to be having at least about 3 more days of presentations that will take our time to go through these. For today's agenda, we're going to be looking at duties and powers of the director. As at 5501.31, we're going to look at the components of the instruments. We're going to take a look at the complying with ODOT's procedures for the instruments, as well as the types of acknowledgments and compensation for the instruments. This course, the purpose of this course is to is the basic principles of complying with the law when using ODOT instruments and the entities that use them when acknowledgement forms for ODOT highway projects. So basically, it's just we're going to cover just the basics of our instrument process and how it actually would work. Of course, ODOT is governed with many laws, many regulations, just as any other agency or state agency or federal agency. And the process of real estate is also covered by many laws and regulations as well. But one of the primary focus of the law that we're going to be looking at is out of 5501.31 duties and powers of the director. And this is out of the Ohio Revised Code. This is the citation here out of 5501.31 Director of Transportation Powers and Duties. There is a lot of information in that. And then we kind of summarize some of these paragraphs that we have here. The first paragraph basically deals with the director of the general supervision of roads and highway systems, making sure that having the ability to straighten, widen, and align. When you're looking at the next paragraph that's highlighted in kind of a pinkish reddish color, allows the director to be able to purchase and appropriate property that's necessary to locate, construct improvements for bridges and highways. We also look at it, the next paragraph where property is to be appropriated by the director or taken in the name of the state, and forms to be prescribed by the Attorney General. So as you can see, there's quite a bit that is in that section of law that we have. Now we're going to focus a little bit more on what the topic is, and that's when we're going to look at the third paragraph, where it gets into the forms that's prescribed by the Attorney General. And I believe that attachment you do have for yourself. So when we look at the forms that's prescribed by the Attorney General, one of the things that we look at is, so if the AGO must prescribe these forms and instruments, how do we acquire the real estate? Well, the Attorney General's office created some standard instruments and forms that's prescribed by the Attorney General office that allows us to be able to acquire the property. Now, the people that use these particular forms are ODOT staff, consultants, can use these standard instruments and can comply with the Ohio Revised Code. And how do they do that? You got to use the current version. That is very important to use the current version. ODOT has a website that basically houses all of the current forms, and it's important to download and use the most current forms. Sometimes these forms do change. We're going through a change right now, in fact, with our acknowledgement form, so it's important to use the most current version. Do not modify the instrument. And what do we mean by do not modify the instrument is that we don't want people just going in, modifying the language to that instrument to what they feel that is necessary. All that has to have pre-approval. We're going to talk about that. Just insert the pertinent information into the prescribed blank areas of the form. So we'll be talking about that also as well. All right. So when we're looking at with ODOT's procedures, the instrument, in complying with the instrument, an agreement is reached between ODOT and the landowner. There is a closing that's always scheduled, and ODOT acquires the property rights, having the owner convey those rights to ODOT. The property rights are conveyed by an ODOT instrument, and the instrument must be recorded to be enforceable. All instruments must be approved by the Attorney General's office, by the Ohio Revised Code, which is out of 5501.31. And we've seen that already, but I'm going to re-highlight that for you again. And as you can see that it gives the definition of it, but the one that we're going to be making sure that we focus on is the area that is in accordance with the forms as prescribed by the Attorney General. It is contrary to ODOT's policy to alter any of the wording of these forms without pre-approval transportation section of the Attorney General's office. kind of
Wayne,
covering this. Yes.
if I get a chance, it's Greg Severance here, folks, just to jump in real close there, just in case some of you don't know what fee simple is in terms of a interest in property, that's everything basically. A lesser estate would be obviously something like a life estate, which the state would never take, but other people may have, where they only own the property for as long as they live, and then it kicks over to somebody else upon their death. So essentially what we do with the state is typically fee simple, but sometimes we do something like a standard highway easement. That's how ODOT used to hold property in the past. And we still do that sometimes yet today. So, and we also may do things like easements, you know, for drainage or something like that as well. So that's it. That's what I wanted to chime in on.
Thank you so much for clarifying that. I appreciate that. That's very important. So when we're looking at the instruments are created by the preparer who selects and assembles the correct series of forms that's included on the instrument. So whoever handles the preparation of the instruments, typically we look at the realty specialist that would handle the preparation of the instruments. Since they're working directly with that property owner, sometimes others might prepare the instruments, but no matter what, is important to understand the selected areas that's necessary to get the correct forms for the instrument for that particular property and the property owner. The basic instrument that conveys a property right from the property owner to ODOT contains 3 parts. And these parts basically we're going to look at, and its individuality is the conveyance section and the acknowledgement section and the description section, which we also call it an Exhibit A. And one of the things that's important is that that it must be in that particular order when you start assembling those particular instruments together and everything. So when we're looking at the defining the instrument, which an instrument is the legal document that transfers the property right needed for the highway project from an owner to ODOT. An instrument must be recorded to be enforceable. If your instrument, if you acquire the property from the property owner, and if you don't record that, basically you're going to have issues down the road because you don't have actual legal right to be on that property till you get it recorded, because somebody else can also beat you and record that instrument as well. So it's important to get it executed and get it recorded to make it enforceable, as well as paying the property owner.
Wayne, the key to that is like any agreement between 2 parties is enforceable as to those 2 parties because they know what they did. The recording of anything like a deed is noticed to the whole rest of the world.
Exactly.
The whole rest of the world is presumed to know what's been recorded, and much easier today that most of this stuff is online and you can check it. So you can imagine what it was like in the past where you didn't even have that. But if it was recorded down at the courthouse, buddy, you were supposed to know it. It's what they call constructive notice.
There you go.
And that's why it's very important to have it recorded, like Wayne said, because if someone else records like a lien in between, you know, our purchase, our closing, and our recording of the deed, that lien is on there then. Mm-hmm. So that's why we want to record these as timely as possible.
Exactly.
Okay. Sorry to interrupt again, Wayne.
Oh, you're fine. All right. An instrument cannot be amended. That is very important. We kind of talked about that before. You're going to see that throughout the presentation. The instruments cannot be amended by the without the approval of the Attorney General section of the Department of Transportation. And then once again, we provide that citation of the reason why is because the forms have to be approved by the Attorney General. So we cannot amend the forms without their approval. If an owner or an owner's attorney, that does happen, request an instrument or form to be modified, the agent must do the following. Need to notify the manager. The manager generally is the first key point. If you're working with the consultant is working with ODOT, the manager of the project needs to be aware of what the situation is. The manager generally would have the answer, but if the answer goes a little bit beyond its complexity, then it goes to the next step. The manager will seek assistance from the Attorney General's office. And in the event that the transportation section attorney does not approve that instrument, which basically came from that request of the property owner or the property owner's attorney, the property will be appropriated so that we can secure the property rights of that project. This regulation goes beyond the instruments also as well. It goes along with our contracts of sale of purchase. Our contracts of sale of purchase is what we use. The forms that you see there is RE220L, which is for land and improvements, and RE220B, which means is for buildings. And so it goes along with our contract of sale of purchase, as well as our right of entry form of the RE222 for right of entry of the property. ODOT instruments consist of 3 sections. It consists of the conveyance section, which is the first page of the instrument. It consists of the acknowledgement section, and that's the part of the instrument where the owner would sign. The acknowledgement section is also important electronically and inserted into the conveyance section of the form. This particular document is not a standalone document. People used to print those off and just attach it. And the purpose of it is to show the continuous flow of the acknowledgement form along with the rest of the information in the document. The acknowledgements on the ODOT instrument must be notarized. Witnesses are not needed. We don't have witnesses. That's been done away with for a period of time. There are no signature lines for the witness. The latest, this is the latest page of the instrument that is showing this reference here. And then with regards to that, it also shows the legal description section as well as the needed for the highway project. And then as well as the description section is going to be being created by the district. So basically that's how the creation of that particular description section is. The description section is also attached to the instrument. And that is a document that should never be typed. So on the only thing that you're going to attach to the conveyance form, which is also part of the acknowledgement form, will just be the description section, which is known as or referred to as the Exhibit A.
Yeah, Wayne, real quickly on that too, why the description should never be retyped, and we don't have to worry about it so much now that we have, photocopies and word processing and stuff that can, the computer basically stores these documents for us in that way. But if it used to be that if that description did not mimic exactly the prior description, then there was a question as to whether you really took the property or not. I know how strange that sounds, but it used to be back in the old days, at my time, that literally the attorney and the secretary would sit down and the attorney would read it while the secretary, read the thing along with his reading to make sure that it said exactly what it said, and that included in punctuation and everything.
Right.
So nowadays, though, it's much more simpler. Plus, the other part of that description is that now the engineers, the county engineers are basically approving them. So we have to have that seal of the county engineer on it.
Exactly.
So thanks, Wayne.
You're welcome. That's what we bring up the next screen, where basically what Greg says is that the county engineers required ODOT to have the description section pre-approved by the county engineer. They use a color stamp to show the original stamp for that, and that the original color stamp must be a part of the instrument so that it could be recorded. So the conveyance section of the instrument, it describes the property right taken. And so since it describes the property right taken, it describes with the parcel number and the what's being acquired. So it's 8WD in this case is showing parcel 8. The interest that's being acquired is warranty deed, or in this case is using the parcel 12 warranty deed with limitation of access. And so basically that's how the instrument is described in with our portion there. And then of course it references the exhibit A. The conveyance section form is divided into the sections, such as we have forms for the fee taking, and we have easement forms for takings, and our easement forms are broken into our perpetual easements as well as our temporary easements. So what does the conveyance form describe? It talks about and gives us the grantors, the name of the grantors, the amount of money to be paid to the property, to the owner of the property, identifies the right-of-way of the parcel, which we kind of talked about that before, the parcel numbers. It references the Exhibit A with regards to that portion of the conveyance form. All right, so now, gone through a few slides, we're just going to say on this particular part here, it also is prior to the instrument reference, which is the recording information that handles the volume and page from the deed, which claims the title, and then the auditor's parcel number, which is the APN, or the permanent parcel number, depending upon which county is being used in. All right, it is time for a knowledge check. We're going to go through a few knowledge checks. And Victoria, do you want to take over?
Sure, I'll go ahead and put those poll knowledge check questions up. So the first one we have is, what is the Ohio Revised Code, ORC, that gives the Ohio Attorney General the right to prescribe the form for ODOT? I'm going to launch the options here. And if you could please go ahead and put your answers in. Just take a guess if you don't remember exactly, because we are not tracking how you answer on these. If you can't seem to answer the question on the screen, it won't take it. It's probably because you're in full screen mode. Just exit out by hitting escape, and then you'll be able to vote. You're voting quickly, Wayne.
Oh, good.
We're almost up over 80%, so I guess everybody's had plenty of coffee this morning.
I've had tea. I need more coffee.
Great. Tea is good too.
It is.
All right, I'm going to go ahead and close the voting out and share the results here. We have 95% that chose 5501.31 and 5% that chose 555.55. So
okay.
I will hide that and let you share the answer.
Okay. There is the selection of the answers, and if you select 5501.31, number A, letter A. All right, next one.
Right. All right. Can the ODOT forms be used by ODOT staff and consultants? So I've launched this one. You have options of true or false. And the quicker you vote, the quicker we move on to the next question. So you guys took me seriously. The percentage just ramped up All right. I'm going to go ahead and close this out and share the results. It looks like 100% of those who voted chose true. So Wayne, I'll leave it to you to share.
And they selected the right answer. Question 3.
All right. When dealing with a signed warranty deed instrument, what must be done for it to be enforced? I'm going to launch the poll, and you have options of putting the deed in the file after signature, keep the deed on the desk for reference, recorded, or none of the above. They're voting quickly on this one too. So, all right. I appreciate everybody being on top of things this morning. This makes us so much easier. Okay, I'm going to share the results. We have 96% that chose recorded and 4% that chose none of the above. So I'll hide those responses. Wayne, whenever you're ready.
All right, so there's the selection of answers, and if you chose C, you chose the correct answer. Number 4.
ODOT's instrument contains how many parts? Here's the answers we have for you. We have 1, 2, 3, or 4. While you guys are wrapping up your voting, I would like to point out that in the chat box, I put a link into a web page I set up that has all of the handouts for all of the days on it, including this case studies. So if I'll email that link out to everyone as well after the webinar is completed. All right, I'm going to close the voting out, share the results. We have 5% that chose 2, 86% that chose 3, and 9% that chose 4. So
Okay.
I'm hiding those results, Wayne, and it's all yours there.
All right, so it's a selection of answers, and you should have selected C. There's 3 parts. Okay.
Great. Can instruments be amended without the Ohio Attorney General's approval? I'll launch the responses. We want to know yes or no. Greg, you'll be happy when you see the results on this one.
I don't know about that. It means more work for me.
No, job security.
There you go.
So, all right, I'm closing the voting out and I'm going to share the results. We have 4% that chose yes, but 96% that chose no. So I'm going to hide those answers. And Wayne.
And this answer is B, no. All right.
And then the acknowledgement form must be a standalone page attached to the conveyance form. And you have options of true or false. Well, there's an interesting split on this one. We'll let a couple more people vote here. All right, I'm gonna close the voting down and share the results. We have 42% that said true and 58% that said false. So Wayne, hide that and it's all yours.
And the answer should be false. If you remember, we need to have it a continuous flow of the page. It cannot be a standalone page. So this was good.
And again, this is Greg piping in. The reason we do that, it's not necessarily a legal requirement, but it's a logical one. Think about yourself. If you're signing a contract, would you just sign a separate page that could be attached to any other document at a later time? You're not given carte blanche to use your signature for everything. Wouldn't you feel a whole lot better if you could sign like at the bottom of the page of all the stuff that you're agreeing to?
Exactly right.
That's why we're doing it. That's exactly it. So.
Exactly right. All right. All right. We're going to move to the section of compensation. Victoria, I just want to see if there's any questions over the previous information, because now this is a little bit different area we're going to go into. And if no questions, we'll keep going.
No questions yet.
All righty, we'll keep moving on. All right, the amount of compensation shown on the instrument. So when real property is acquired, the property interest that is purchased is conveyed to the state of Ohio by the owner of the instrument that has been pre-approved by the Attorney General's office, the AGO. All such instruments require full amount of the compensation paid for the given parcel or the group like parcels to be shown on the instrument conveying the parcels. So we're going to go through a few examples just to elaborate what we're talking about. So we have an RE22 that's list compensation for a WD, which is warranty deed acquisition, as or fee simple, at $15,000. The amount is allocated $10,000 for part taken. This is what you would see on ODOT's RE22. $5,000 for damages. What amount of money should be shown on the instrument form? And the answer would be $15,000. So it'll be $15,000 on the instrument that was shown what was being acquired. Example number 2, same information as example number 1, except the owner did not accept $15,000 offer, but the owner countered at $18,000. ODOT accepted the counter offer by administrative settlement. What amount of money should be shown on the instrument? That'd be the $18,000. Example number 3, using the same information as example number 2. Assume the owner asked to retain an improvement. The salvage value is $2,000. The district real estate administrator agreed to the retention of that improvement. What amount of money should be on the instrument? The answer is on the instrument is still $18,000. ODOT is required to purchase and own the improvement to secure the property rights to make sure the right-of-way is clear. So we need to show first that ODOT is buying the improvement, because we have to ensure that the right-of-way is clear of improvements first, of encroachments. So we need to make sure that the improvement is removed so there will not be an encroachment. Let me clean that up there a little bit. Typically, retention process is still documented within the contract that stipulates the owner receiving $18,000 consideration. The warrant is decreased by the owner retention of $2,000, the improvement resulting in a $16,000 warrant, because he's still receiving a value of that improvement of $2,000. So that's the reason why the instrument will continue to show $18,000.
Wayne, just to jump in here real quick too, just
absolutely
some very basic concepts, again, that probably everyone knows, but just to remind them of the difference between compensation and damages. Compensation is paid for what you're actually taking, like the land and improvements. Improvements could be anything. Typically, they're thought of as fixtures, something that's attached to the land. The most common improvement that we see that the owner wants to keep is like a sign. That's, you know, that's why there's a salvage value assigned to those type of things. And because that comes off of what we're actually buying then. We shouldn't pay for something we're not acquiring, that they're keeping instead. Damages come about as damages to the property that's left for whatever reason. Maybe the property now is too small to support a commercial use or something like that, or maybe it had 2 access points and now only has 1. So the way damages come up, they should come up through an appraisal where the original property is appraised. Then, and that's what gives you the per acre or square foot value of what it is that you're acquiring. Once you subtract the compensation from that, that in theory should be the value of what the remaining property is. But the second appraisal is the appraisal of the remaining property. And if that is lower than simply subtracting the compensation from the original value, then the difference, that lower value, that somehow there's damages in there somehow to the property that remains. And that's how damages come about. They're not just looked at like, oh, well, we took some trees, so that's a damage. No, because the trees are figured into the original value to begin with. And they may account for some damages later because, you know, the place sat in a beautiful grove or something and no longer does. But that you look at the total value of the overall property before the taking and after the taking. And like I said, if that's not simple arithmetic by subtracting, you know, the amount of the compensation, the amount that was taken, then there must be damages. That's how that comes up. And that's how they arrive at that. So that's my 2 cents.
Thanks, Greg. I appreciate it. Let's move to another example. Example 4. The warranty deed, which is the WD acquisition, touches a residence, and the portion of the residence on the residue property is removed by a T. A T means it's temporary acquisition or temporary easement. The total FMVE is $57,700. We're going to take a look at the breakdown here. The RE22 lists compensation for the WD acquisition at $57,500. And the RE22 lists compensation for the temporary at $200. The warranty deed allocates into $7,500 for the land to be taken, the residence at $50,000, and no damages are shown. And we look at what amount of money should be shown on the instrument. Now keep in mind that we're looking at a temporary that's going to be taking the house, the temporary area, because the temporary area as it is, once the construction is done with the removal of the structure, the temporary is actually returned back to the fee owner. And then of course we're looking at the WD for taking the structure of the land. So the answer is that we're going to have 2 instruments that's going to be needed. We're going to have one property right to be acquired by WD and another for the rights of way to be acquired by the T for its temporary. And then we look at for the dollar amount. So we look at the dollar amount shown, whereas the warranty deed instrument has $57,500 and the temporary, which is the T, has $200 on it. When we take a look at the conveyance forms, that's classified into 3 categories. We're looking at the fee taking, which is the warranty deed, the WD or the WL. We're also looking at easements. So permanent easements, we get into standard highway easements, your SHLA, which is limited access, your slope easement, and etc. So there's plenty of other easements that we show, that we have. And then you have the temporary easements for when we're acquiring parcels on a temporary basis for the purposes of grading or reseeding, then we return that portion of the property back to the property owner that has been regraded, reseeded, or if they have to do a small little bit of repaving back into the driveway approach. Conveyance forms are to identify the organization that's paying for those acquisitions and the organizations that will take title to the property. So we put that underneath the temporaries as well as any other instruments or whatever organization that is acquiring, to make sure that they're the ones that's going to be identifying and paying for that acquisition. This here is a conveyance form chart, basically just showing you if you have an instrument that's located on the left side that you would see, and then the taking in the name of ODOT and payment by ODOT, you'll see those fee conveyance forms that we have. So it's the RE202 or the 205 or the 208. Next to that is when it's an LPA, local public agency, but payment by ODOT. So we have a little bit of different form with regards to that because it's payment by ODOT for this particular agency. So we have a little bit slightly different form on that there. All right, we have now gotten to any questions before we get to Greg's part. Any questions, Victoria?
No questions up till now.
Okay, Greg, you're up.
Okay. And guys, I'll have to tell Wayne, since he's the presenter, when to switch slides. So basically my talk is about the components of a deed. You'll see general warranty deeds and limited warranty deeds. Those are essentially your two types. So Wayne, the next slide. And that's our handout, an example of a warranty deed, a general warranty deed. And as you can see, there's the granting clause, which is typically the first thing, identifies the grantor and grantor's marital status or nature, such as a corporation, and the grantee should identify that as well, and the type of warranty. In other words, general warranty as defined in the revised code, the Ohio Revised Code 5302.06, which is that the grantor, the seller of the property or whatever, is basically warranting that they have title to it, that they're allowed to convey it, they're allowed to transfer title, and they're basically warranting that they will defend that good title against all comers. Property description clause comes up next. And of course, that identifies what is being conveyed. ODOT's pretty good about that. Theirs is a little bit different than what you see on normal deeds because we identify the county, route, and section, whether it's limited access, that type of thing. And if it's a deed for a temporary easement, we obviously put that in too. That's not the same thing as the legal description, which will show up at the end, which is generally Exhibit A and attached at the end. And that's the legal description is the thing that has to be approved by the county engineer, not this property description clause. That's just within the deed. The habendum clause, which by the way, I finally was curious enough to actually look up why in the world is it called an habendum clause? There's not a good answer to that other than it's old Latin, and that's the way it used to be done back when they first came up with deeds. So, you know, enough about that, because I hate that word, but hey, it's got to be called something. And there's a number of things that fit in the habendum clause. As you see, it defines the extent of the grantee's ownership of the property. In other words, the grantor is transferring the property in fee simple. You know, well, that means transferring all of it, all the rights to the grantee, to the buyer. Again, when we're only taking, say, a standard highway easement or a slope easement or drainage easement, that's much less because the underlying property is still technically owned by the original owner, and all the easement gives ODOT or anybody that purchases an easement is just a right to use that property in the way that it's described that they can use it for drainage or whatever, or for access. And they cannot, that easement shouldn't interfere with the rest of the property, other than what's already been, paid for in a sense. And the owner, the owner that still owns the underlying fee, as it's called, can't interfere with that easement, can't interfere with the use of the easement. So that's why that's important to keep that in there and to put that in there to let everyone know who owns what and who can use what. So the handout is the next. Trying to think.
Page 2 of the RE202.
Yeah. Components of the general warranty deed, again, section 163.02D of the revised code requires every instrument from ODOT, or which ODOT acquires property, that ODOT has the power to appropriate, and also to include a statement of public purpose of the property. ODOT cannot take property, since it's a public entity, it can only take it for a public purpose. It cannot take it for a private purpose. One of the problems in the past was that ODOT might acquire property and give it to a neighbor so that they could have access or whatever. Well, we can't appropriate to do that. We could purchase possibly to do something like that, but we cannot appropriate. In other words, we can't gore one person's ox to help another person. So let's see, the section 163.211 of the Ohio Revised Code creates the right of a grantor to repurchase the property. This is a somewhat recent thing, came up, I don't know, about 15 years ago, because sometimes ODOT would acquire property and the project would not occur, and might not occur for a number of years, to the point where it literally goes off the list of things to be done. Well, if that's true, then the person that ODOT acquired the property from has that right then to repurchase the property. And it defines, this paragraph defines specifically how or when that right can be done. It doesn't exist forever, and it's done in a way that ODOT and the previous owner come up with appraisals, and if they don't agree, there's a system to go through with that too. But essentially, it's a negotiated concept, as to whether they want to repurchase it or not. Sometimes they do, sometimes they don't. But in my experience, in the years that I've been working here with ODOT, I really haven't seen that occur, to tell the truth. I've never seen anybody enforce this provision. Components of a limited warranty deed. And what we're talking about here, again, the same thing. It's just a deed. Just like the general warranty deed, it's going to have the grantor, the grantee's name, and again, what type of grantor is it? Is it a married grantor? Generally, with the married grantor, you're going to see Mr. and Mrs. or whatever type of thing, which will indicate it right there. In previous deeds, they always had like so-and-so widower, or unmarried or married would be the typical things that they would put in. You're seeing much less of that now. So even though that's kind of a requirement, it's not done as much as what it was. Property description clause, again, is the same thing we talked about. It's going to be similar to the general warranty deed in the sense that it's a quick snapshot of what ODOT is acquiring, but it's not the legal description, which is Exhibit A attached at the end. Then the final one, the habendum clause, is again, what are the rights that are being acquired? And notice here too that here we're getting a limited warranty, which means that the grantor is not warranting everything. He's just warranting maybe that he has title for the property and that no liens went on to this property during the time that he or she owned it, you know, for the past 20 years that they owned it or whatever. Another form of limited warranty deed is a quitclaim deed, which ODOT doesn't like to take, because the problem with that is there are no warranties at all. What the grantor is doing is simply transferring whatever interest they may have in the property. And this happens sometimes when there's what we call a cloud on the title. Nobody's really sure who owns it, but this one person might, and maybe they don't really care. They don't want to own it. They don't want to pay taxes on this thing. So they just simply say, well, you can have it. I quit claim my interest. So that's what'll happen that way. And it's very rare. We frown on getting a quit claim. Occasionally we accept them in that weird situation like what I mentioned, or sometimes corporations have a real problem signing a warranty deed. And occasionally we'll let them slide, because typically they will have owned the property for a long enough time and our title work is good enough that we're not worried about them warranting title. So here's the handout as well. Again, that we have to put in that the ODOT has the power to appropriate, and that the property is acquired for a public purpose. Obviously, ODOT's public purpose is the making and building of roads. Got to be connected some way to that. In fact, that's to go back to the powers of the director very quickly that we mentioned at the very beginning. Everybody always thinks, well, that's pretty unlimited. Well, there's actually a limitation in that part of the statute about bike trails and bike paths. We can't acquire those by appropriation. We can buy those, but it has to be a voluntary sale. We cannot appropriate them. So that's like a limitation on the director's powers. Let's see. Again, the statutory right to repurchase the property if it's not used for the purpose that it was said it was going to be used for roads, basically. And the right, again, like I said, to repurchase it. There's a way that, like I said, that sometimes that can be extinguished after about 5 years. So it doesn't go on forever, but you know, it's still there. It's typically like, well, ODOT thought it was going to do the project, then the plans changed, and now they don't need the property that they thought they did. That's generally what you'll see in that type of situation. And they turn it back around and then sell it back to the original owner if they want it.
Okay.
Components of the limited warranty deed, we've really covered this already, essentially. Same thing, again, as the general warranty. The difference is it's just a limited warranty. It's limited to situations or whatever. They may, you know, they may limit a part of the property, or they may, there may be some limitation involving an easement or whatever. So we tend not to see those too much, because like I said, generally what ODOT wants is that general warranty deed from people. And general warranty deed typically works because the title work is much better than what it used to be. What with the computerization of the recorder's office in various counties and stuff, the accuracy of the title work has been greatly improved. And the accuracy of surveys has been improved because of the GPS, the global positioning system that surveyors use now. So limited warranty deeds are going a little bit by the wayside. They're still around. You'll still see them. But like I said, they're frowned on by ODOT. ODOT prefers the general warranty deed. That's the best way to go.
All right. And are there any other questions? Because we have just now concluded our presentation. Victoria?
There is one question. Can the repurchase price be agreed upon at the time ODOT acquires property?
It could feasibly, yeah. Typically though, that's what that clause talks about, is it's hard to predict the future, but you can kind of agree to anything in a sales agreement. I've never seen it happen, but it could. And again, that would be a change that would have to go through the Attorney General's office and be approved by the Attorney General's office. But I could see a possibility. You have some intransigent property owner that says, well, yeah, but they're talking about this project may not happen for 2 years. So, if it doesn't happen in 2 years, can I buy it back for, the same, or maybe, a 5% increase or something, or a 5% diminution, or at least buy it back for the same thing as what I sold it to you for. That's probably what they're looking at.
Right.
They want to get, they want to get their money back, in a sense. They want to get their land back, and they don't want to have to pay a premium for it. And that's fair enough. I would say that's a fair enough thing. I just have not seen that yet.
Right.
Typically, that doesn't happen. It could, but a lot of people, like I said, just nobody's really enforced that particular paragraph yet. So we'll kind of have to wait and see. But I could see where there could be some sort of agreement like that that could come about. So it would make a certain amount of sense to me.
Thank you for the response. Now, we don't have any additional questions in the question box, but I had a question for Wayne regarding the handouts that we have placed out there on the web page for everyone. There were 3 case study handouts, and I believe they were all listed as being related to day 2.
Right.
So I just wanted to clarify that even though there's case study 1, it's actually related to the next session.
Exactly.
Okay. Sounds good. All right. Well, I believe that's all then for today. Thank you everyone for being on here so bright and early. And we look forward to having you on the next session. And hopefully whatever questions you come up with between now and then, you can either save them up, or you do have Wayne and Greg's contact information. You'll be able to send them to them directly. So everyone take care. Have a great rest of your day. And Wayne and Greg, is there anything else you'd like to add?
No, that's it. We're good.
No, other than if you hear a dog barking in the background from me, that's not my fault.
That's okay. It's par for the course these days.
Yeah.
Exactly.
All right, everyone. Take care. Thank you.
Thank you.
Bye.